I'm criminal defense attorney and domestic violence lawyer Aaron J. Boria, and today I'm going to tell you 5 things, that's right, 5 things you need to know about being charged with domestic violence in the state of Michigan. First off, what is domestic violence? Domestic violence is an assault and battery. An assault occurs when you intend to put someone else in fear that you're going to batter them. A battery can be hitting, but it can also be anything offensive, such as pushing someone or spitting on them or grabbing something closely connected to them. For instance, if someone had something in their hand, like a purse, and you yanked on it in order to offend them, that would be a battery. What makes it domestic violence is that there's a relationship between the two people that the assault and battery occurs between. The most common relationship I probably see could be a dating relationship or husband and wife, a spousal relationship. But it can also include people that live together, like roommates. So what's the penalty for domestic violence? A first offense for domestic violence is punishable by up to 93 days in jail and a $500 fine plus costs. A second offense is punishable by up to a year in jail and a $1,000 fine. A third offense is a 5-year felony with a $5,000 fine. There's also something called aggravated domestic violence or aggravated domestic assault. Aggravated domestic assault is charged when there's a serious injury. By law, that means an injury that requires immediate medical treatment, serious disfigurement, or causes permanent health problems. The penalty for aggravated domestic assault is 5 years in prison. And as a collateral consequence, under federal law, a conviction for domestic violence, even the misdemeanor 93-day offense, will result in your inability to carry a firearm or even ammunition. Yep, a domestic violence conviction means no more guns and no more ammo. You cannot be in possession of it. No contact orders. What is a no contact order? A no contact order typically starts out as a bond condition, but it can continue through the entire case and during the time that a person is put in jail as part of their punishment, or if they're put on probation. The no contact order can continue for that entire period of time. A no contact order is just that. You cannot have contact with the person the judge orders you not to have contact with. Some no contact orders will order that you can't go to your own home, which could mean that you can't get your kids to school, or you can't get your clothes or your belongings, things like that. It doesn't matter. If you're told that you can't go to a certain address or have contact with a certain person, then you can't have that. There are some situations where a judge will lift a no contact order if the person that the no contact order is against is agreeable to having that order lifted. Can I drop domestic violence charges? This is a common question that I get at least once a week. And for the most part, the answer is no. In a domestic violence case, it is the government against the defendant. It is not the person who made the domestic violence claim against the defendant. In other words, the case is going to be the state of Michigan or a local city versus Johnny defendant. So even though you're the one that made the complaint, typically you cannot just ask for the case to be dismissed. It is the government's case, it is the prosecutor's case, and it's up to them if they want to dismiss it. I once heard a judge say this, and that was, when you invite the government into your home, it is not on your terms. So when you make that phone call, you better be sure that you want to proceed with the charges. Now, in a case where you do not want to go through with the charges, that can help to get a more lenient resolution, and in some cases, it can help to obtain a dismissal, but it is not automatic. There are defenses to domestic violence. First off, domestic violence cannot happen by mistake or accident. If whatever action is being claimed as domestic violence was a mistake or accident, then you're not guilty. Also, if you were acting in self-defense. Self-defense is an absolute defense to domestic violence, so if you were acting in self-defense, then you are not guilty of domestic violence. There's also something called the defense of others, and that is where you step into the shoes of another person who would have had the legal ability to claim self-defense. So if you were defending someone else who was being the victim of an assault and battery or some sort of attack, and you stepped into their shoes to defend them, that is defending another person. That is legal, and that would be a defense if you ended up being the person that was charged. A very common defense is that the allegations against you are a lie. There are probably more false claims about domestic violence than any other case that I see. It isn't uncommon for me to see a claim of domestic violence during a heated divorce or during child custody arguments. I also see claims of domestic violence made when a couple or someone gets into an argument and they want to show that other person who's boss, and they make a false claim of domestic violence. Oftentimes, these lies can be proven by other actions, past history, and other incidences that you've had with the person that is making the false claim against you. There are probably many other defenses that I haven't listed here that are unique to your particular case. You always have a right to go to trial, and the prosecutor has to prove your guilt beyond a reasonable doubt. There is a program under what we call the Spousal Abuse Act. It's MCL 769-4A. You'll hear attorneys often refer to this as 4A or 4A status. This is a special statute that allows someone to plead guilty or no contest to domestic violence without having the offense go onto their public record. As long as the person completes a term of probation, stays out of trouble, does everything that's ordered, then the case will be dismissed and it will never show up on public record. This will also have the effect of saving the person's ability to carry a gun once they've completed the program. It'll also allow them to legally say that they've never been convicted of a crime. This is a great result for someone that is guilty of a first offense. I'm criminal defense attorney Aaron J. Boria, and I represent countless people, men and women, accused of domestic violence. I have an amazing track record, I win at trial, and I know how to fight these cases. If you've been charged with a crime, give me a call. I can be reached at 734-453-7806. I get results that other attorneys simply do not. No one will fight harder for you than me. Call me today.